Now from the party leaders, leader of the UKIP group, Neil Hamilton.
The Government will be represented at the Supreme Court hearing next week on the case involving Article 50, and that's perfectly reasonable. The Welsh Government's views should be presented to the court. But what instructions will be given to Council for the Welsh Government? Will he be, or she be, supporting the Government of the United Kingdom, or will he or she be supporting the claimants against the Government of the United Kingdom? I.e., will he be helping to facilitate the wishes of the British people as expressed in the referendum on the 23rd of June, or the opposite?
Neither. The Welsh Government will be representing itself, and the instructions to Council will be given on the basis of representing the Welsh Government's position. This is not to do with preventing Brexit. It's to do with making sure that constitutional law is observed.
Well, there is an argument, of course, as to what the constitutional law requires in this particular instance. What I'm trying to elicit from the First Minister is on whose side is he going to be, on the view which is held by the United Kingdom Government, or the view held by counsel for Mrs Miller, who is the applicant in this case. There are sound legal arguments for saying that an explicit vote of the House of Commons is not required before triggering Article 50. In 2008 and in 2011, an Act of Parliament was passed to amend UK legislation to require explicitly a vote in Parliament if there were to be any specific changes to EU law in some areas like common defence policy, the appointment of a European prosecutor, whether Britain should join the Euro, whether Britain should join the Schengen Agreement, whether we should replace the voting by unanimity by qualified majority voting, and a whole range of incidents. In all those instances, there would be direct effects upon the British people as a consequence of the decision. That's the essence of the High Court's decision. It's because of those direct effects upon people that an explicit vote in Parliament is required. But as Article 50 was not one of the many instances which were set down in an Act of Parliament, then there is certainly no basis for saying that in this case there is an implied requirement for the House of Commons or the House of Lords to support a vote in favour of Article 50 before the Government is enabled to fulfil the wishes of the British people.
Well, if the leader of UKIP is pitching to act as counsel in the Supreme Court, he's doing a reasonable job for himself there. He understands the constitutional issue, but it has to be resolved in court. We will all have our different positions. The question for us is, can the royal prerogative be used to start what would be an unstoppable process towards changing the Constitution of Wales? There are serious legal arguments that need to be explored in the Supreme Court. He has recognised that. I welcome that. Unfortunately, there are some in his party who see this as some kind of conspiracy to stop Brexit. That is not what this is about. This is about ensuring that an important constitutional legal principle is examined and judgment given on that, not just for Brexit, but of course this could be used in the future for other issues as well.
Indeed, and so what I'm trying to elicit from the First Minister, and which he still has not given an answer to, what will Counsel for the Welsh Government actually be saying in the course of these proceedings? Because Counsel for the Government said nothing in the High Court at all. Is it intended that Counsel for the Welsh Government will say something in the Supreme Court hearing? And if so, will he be arguing against the case of the United Kingdom Government that we should go ahead and trigger Article 50 as soon as possible without complicating matters by having further votes in Parliament?
Well, I mean, he's perfectly welcome to read the grounds, which are public, and he will see the case that we make. We represent ourselves. We are not there to back one side nor the other, but to put a case on behalf of the people of Wales in terms of what constitutional principles should be followed. It just so happens that Brexit is the issue, but it could be any other issue where this constitutional principle would need to be examined, so it's important that it's examined now.